the probate process is a process. People are very concerned. A lot of people say, well, how do we avoid probate, or how come we have to probate a will? When you execute a will at a lawyer's office, that document is a document. It's a will. It's a document entitled a will, but there are certain qualifications that have to be met to determine if it's a good will. A will normally has to be signed by the person who's making it. It's signed in front of who has to be competent, not suffering from any undue influence. The person has to sign it generally in front of two witnesses. The two witnesses have to sign, and has to be a factor called a will ceremony, in which this person declares in front of these witnesses that this is his will, and he's reviewed it, and he would like the witnesses to sign the will. So there's kind of a whole process that needs to be done. But so when that's completed, it's a document purporting to be a will, but it's not a will yet. A will is not determined to be a valid will, which gets to the appointment of the executor. The person in charge is not yet an executor until the person dies, and the will goes in front of the surrogate court judge, who makes a determination that that's a valid will and appoints the executor in charge. Now, this could be a very simple process. It can be just a question of submitting paperwork and paying a filing fee, and it's done. And the paperwork in part has to come from the person who's petitioning for the will to be admitted to probate, but it has to come from the individuals who have a right to contest a will. There are a group of people who can contest a will. These people are known as distributees. There's another group of people called people who are adversely affected. Distributees are individuals who would take a distribution from an estate if there was no will. So, for example, if I do a will leaving everything to my friend, my spouse and children could contest the will on the grounds that if the will was not valid, they would get my entire estate. So that they are the only people who can contest my will. My parents could not contest my will. My first cousins could not contest my will. But those who would take if there was no will. There's another group of people called individuals who are adversely affected by a prior will. If I had individuals in a prior will and the prior will still existed, those people could have a right to object to my will. So the critical point of all this is that when a will is submitted for probate, notice has to be given to those individuals who can contest. Now, the easiest way to probate a will is those people who could contest sign a waiver that says, hey, we're good. And there's documents, and they submit it, and most wills pretty much get probated that way. But occasionally that can't happen. So then appropriate notice through certified mail or process servers of a court date has to be given to these people. And they have the right to come to court and say, I want to object to this will. Now, this is not an easy process, as I tell people. There's only a few grounds you can contest a will. You can contest a will that the person who did it and at the date that person did it was incapacitated, usually mentally incapacitated. That's the first grounds. The second ground is that there was undue influence, that somebody undue influenced him. The classic case of that is the healthcare provider, for example, the aide who said, listen, I'm going to leave you here nobody's going to take care of you. You're going to die here in your room unless you see my lawyer and have the will, everything go to me. I mean, that's an extreme case. You can have a mistake of fact that the person is confused, and then there's something wrong with the will procedure. Now, it is very, very difficult to contest a will because remember, generally speaking, those two witnesses were there, and those two witnesses said, hey, that person signed the will in front of me. That person knew what they were doing. They understood what they were doing, seemed competent to me. when I signed the will. So, generally speaking, if you're going to object to the will, you've got to overcome those folks. And while there are certain cases that you might be able to do it, but it takes a significant amount of evidence and testimony and maybe medical testimony to prove that will is invalid. There are very few wills that are attorney drawn that are overturned certainly in Western New York, I would say. Occasionally it does happen, but very few. Now that doesn't mean that cases cannot be made that there's a problem with the will, and there are certain situations where will contests go on and wills are settled. The estates are settled. People say, all right, I'll distribute, I'll give you this or give you that, and we'll split it this way so we don't have to go in front of a judge. And that does happen. But it is not, will contests are not for the faint of heart. You need a lot of facts, you need a lot of evidence, and they're fairly expensive.